Please be seated. Morning. We have one case scheduled for oral argument this morning, the case of Jeffrey James versus Abraham Hernandez, Jr. individually, Premier Construction Residential LLC, et al. Counsel, you may approach. We have allocated 20 minutes per side for the oral argument. Would you like to reserve some time for rebuttal?
Yes, Your Honor. I'd like to reserve 5 minutes, please.
So noted, Madam Clerk. You may continue.
Thank you. May it please the Court. Good morning. My name is Rebecca Creed. On behalf of Creed and Gowdy in Jacksonville, we represent the plaintiff appellant Jeffrey James. Plaintiff asked this Court to reverse the final summary judgment that was granted in favor of the defendant builder, Premier Construction Residential, doing business as Premier Fine Homes. Normally, the question of whether an agency relationship exists is a question for the jury. Even in amending the summary judgment rule, the Florida Supreme Court has reiterated the bedrock principle that summary judgment is not to be used as a substitute for a trial on disputed facts. But here, the trial court ruled that Premier Fine Homes was entitled to summary judgment on plaintiff's claims for vicarious liability arising under an agency theory. The trial court ignored significantly probative evidence that would have allowed a reasonable jury to find that Abraham Hernandez, Jr., the painter, doing business as Premier Waterproofing and Painting, was actually an agent of Premier Fine Homes and not an independent contractor.
And counsel, could you hone in, what was that probative evidence in your view?
The probative evidence relates not only to the questions under the agreement itself, which reflect material provisions that are inconsistent with the label of independent contractor, but also the other conduct of the parties. And Florida case law is clear that you look to the totality of the circumstances. You look not only to other language within that agreement, but also the actual practice and conduct of the parties. And here, that right to control is what the most important element is. Under this court's decision in Blue, and as recently reiterated in Gradia, it is the right of control and not necessarily whether that control is actually exercised. Here's a practical matter. We have not only a right of control, but also there's evidence to reflect that that control was exercised over the painter. Turning to the agreement first.
Well, actually, would you, let's go to, what was the actual control that you're pointing to?
The actual control is also reflects, as I mentioned, it is the right of control, but there is also evidence of actual control. And here in Mr. Gasvini's deposition, he was the president of Premier Fine Homes. He testifies to the fact that on pages 648 and 649 of the record, he had the right as the builder to dictate material and to dictate performance. And when he's asked about what performance is meant to be, he explains on page 649, not only can we dictate the priority of we need these houses in this order, but you can also dictate the manner in which Mr. Hernandez painted. He's asked on page 649, you could tell Abraham Hernandez, I want you to paint this trim first, and then I want you to spray a wall. Or you could say, I want you to spray a wall, and then I want you to do the trim. You could do that, couldn't you? And he says, yes. He could probably charge me more, but I guess if I chose to do that, yes.
But is this giving priority to either the order of homes or the works? I mean, it doesn't seem that it's even remarkable within the contractor-subcontractor relationship, because the contractor is not just responsible for painters. There are plumbers and tile people and floor people who all may be scheduled over a period of time for a particular house or houses. And you make a lot in your brief and below in the trial court about this prioritization, the scheduling, sequencing. Isn't that just the nature of this business?
That was the argument below by the defendant, that it's in the nature of this business. But here, not only is there an ability to dictate the priority and the order, but there's also specific details on dictating how he would paint and the manner in which he would paint those walls and the manner in which he could repair and would repair and was asked to repair certain items.
So but I think, again, like you're talking about the repairs, so when a subcontractor does work that doesn't meet the specifications of the homeowner or the contractor, isn't it normal that the contractor goes to the subcontractor and says, listen, I need you to repair this, here's what's wrong, here's a way to fix it?
That may be normal, but that may also be evidence of not an independent contractor relationship, but an agency relationship, and that he was not simply turning over the house to say, go paint this house. There's testimony that he was actually had the ability to and did instruct him on how to paint certain areas in the first instance. And so he agrees that we're the builder, we can dictate that. So he has the ability as the builder to do that. And we're not here to argue that every subcontractor has an agency relationship, but in this case there is much more to reflect an agency relationship. Not only is there evidence that Mr. Jasvini had the right to control Mr. Hernandez, he had that ability to control him. And in point of fact, the defendant relies on the Amidas versus Brown case to say, well, here's a case, basically, this case, like other instances you pointed to, where there's a right to, we're simply dictating the priority in which the houses are painted. But in Amidas, the court found and relied on evidence that there the sales representative himself had the ability to control his schedule and to control the context that he initiated. And here, all that was given to Mr. Hernandez. So while in Amidas, that information, that evidence was consistent with an independent contractor relationship, here we don't have that. We have a builder who is directing Mr. Hernandez where to go, when to show up, the order in which to paint the houses, what to do when he gets there, dictated the materials that he used, and his performance. And he admits in several instances, Mr. Jasvini does, of his deposition, that he had the right to and did dictate and mandate performance. And that is an element under, as set forth in the standard jury instructions, it is the right of control, and where there is a right to control the specific means and methods by which an individual works, that at least creates disputed issues of fact as to an agency relationship.
Regarding the control issue, or right of control, you referenced the subcontractor agreement several times in your brief. What provisions in the subcontractor agreement create a material issue of fact on the issue of control?
Yes, on that issue, Your Honor, there are several provisions that show the right of control. The first is this was not a fairly negotiated arm's length agreement. It was entered into by Mr. Hernandez after he'd already worked for Premier Fine Homes for several years. In paragraph 1, the Premier Fine Homes drafts this agreement to apply to every contract, every present or future contract between Mr. Hernandez and Premier Fine Homes. In paragraphs 8 and 9, there are provisions that establish that only Premier Fine Homes had the right to cancel this agreement. Otherwise, it remained in effect. That's paragraph 9G. In paragraph 8, there's provisions, and 9, provisions that if Mr. Hernandez does not comply with this contract, he's essentially unilaterally declared in breach and required to pay damages. He certifies that he has to work according to Premier Fine Homes guidelines and according to their specifications. And again, if there is a breach of contract under this paragraph 9, not only is he required to pay damages in the event of a breach of contract, he also forfeits the right to any sums due to him, even for work that he's already performed, and he waives the right to file a claim of lien and to file for bankruptcy. So those provisions all demonstrate that Premier Fine Homes had the right of control over Mr. Hernandez's performance. He didn't have the right to terminate this contract. That was a unilateral right of Premier Fine Homes. And as we have set forth and cited to the Cantor versus Cochran case, which is a Florida Supreme Court case, the power to terminate is a tantamount to the power to control. And here, there was an absolute right to terminate the relationship of this subcontractor, and it's not consistent with the concept of an independent contractor.
I'm glad you
There-
brought up Cantor. I mean, in that case, the Supreme Court applied the restatement of Agency 220. Why should the Florida Supreme Court and this court continue to rely on the restatements? And if you look at what Justice Scalia has written about the restatements, that they may not be restating the law these days as much as they are restating what the law ought to be. And so, again, understanding that Supreme Court cases are binding on this court, why should the Supreme Court and this court continue to rely on that as a test for agency?
The court should continue to rely on this because it does have continued applicability in this context and in this day and age. And it is a summary of the different factors that illustrate the right of control, and where there is precedent that helps guide the facts and is analogous to the facts here, that precedent should be relied on. I do believe that these facts, it's a restatement of the different factors that are helpful to determining whether there is a right of control. And here, both this court and the Florida Supreme Court have applied those factors.
And I think my question is that, I think Justice Scalia and other justices have pointed to that they may not represent the totality of the cases and decisions on a particular point of law and may be biased in a particular way. So why should we trust those as the test for agency in this case?
Because that is not, in this case, these factors are not biased. I think there is an ability to examine each of these elements and to determine whether these facts are facts that often arise in the context of an independent contractor versus agency relationship. If this court chooses not to apply the restatement factors, it can look to the Florida jury instructions, which are a statement of Florida law. I mean, I realize they're not necessarily, I guess they're an example of the law that should be informed to juries, but in that instance, as followed by this case in blue, it is, again, it's the right of control and not necessarily whether there is automatically that exercise of control. Again, here, we would submit that we do have that evidence, but here there is evidence that Mr. Hernandez was instructed by Mr. Jasvini as to the specific means and methods by which to accomplish his painting.
Again, Counsel, turning to the actual control here, you noted that several factors have been identified to consider in making that determination. In Del Pillar, we identified 7 non-exclusive factors to be considered. Which one of those 7 factors, in your opinion, create a material issue of fact regarding the issue of actual control?
And Del Pilar was a franchise, more of a franchise agreement type of relationship, and so it is a little bit distinguishable, but I think the facts there would include basically the right to specify and control how the performance of Mr. Hernandez in this instance. The fact that he was expected to comply with the builder's rules and regulations, and if he didn't, he would be subject to damages and subject to penalties. There was evidence that there was a right of indemnity, but the Del Pilar case relied on that to say, well, in this instance, that shows that in the first instance, Premier Fine Homes, it was the DHL in the Del Pilar case, but that the owner or the purported principal intended to answer to the public in the first instance and then was going to look to the individual for basically for indemnity. And here we have the same types of facts that there is an indemnity provision, but it's evident that Mr. Hernandez was put in a position to deal directly with Premier Fine Homes customers. He was given that authority, and that Premier Fine Homes warranted his work and intended to answer to its customers as to the quality of the painting. And
Ms.
so-
Creed, and I think, you know, really, this is a case that clearly comes down to the application of the summary judgment standard that you have correctly stated in your opening. I did want to give you an opportunity to address a statement you made in the reply brief in discussing, it's on page 1, notably absent from Premier Fine Homes discussion is any mention of Gradia. And I do note that in the answer brief, they cited it, it was in the table of citations, they cited it twice, and you'll see discussion of the case on page 15. So I just wanted you to clarify that, what you meant by the absence of discussion of Gradia.
By that, I do believe I meant, and I can double check, but that what Premier Fine Homes was arguing was that the lens in which this court has viewed summary judgment has changed since the Blue decision. But I believe in that discussion, Premier Fine Homes did not address or mention the fact that Gradia was decided since Blue and has since reiterated this right of control test. And also, it was merely to show that the standard of summary judgment, what has changed since Blue was decided, is not materially different for purposes of deciding this case.
Were
And
there
we-
any facts set forth in the Blue decision by the court?
I'm sorry, Your Honor.
Were there any facts or factual background set forth by the court in the Blue opinion?
There were facts, but there were not detailed facts related to the nature of the painter's agreement in that instance. But what the court did find was that when you have conflicting provisions within an agreement, it's not enough to simply accept some of those provisions without looking to those other provisions. And so that was enough for the court to find that there was a disputed issue of fact related to how that agreement should be interpreted and whether there were was a right to specifically, a right of control over the specific means of performance there.
Was Blue decided under the old or the new summary judgment standard?
It was decided under the old standard, but again, it doesn't change. It wasn't as if in Blue, this court said, well, there was just, a scintilla of evidence and that's enough. I think there were genuine issues of material fact that were found in terms of the way that the trial court had interpreted the agreement to
But do we
rely
know
only
what
on
the-
certain
what-
provisions.
But do we know what the general issue of material facts were in Blue? Do we know what they were?
Do we know what the facts
From the
were in
record.
Blue? I know what the facts were
Oh,
in Blue.
you know what the record-
But,
What does the opinion tell us?
Okay, so, there were facts stated that there were allegations that that painter was an independent agent of this turnkey properties, and that he was driving his van and struck the plaintiff. But the Blue Court does rely on the well-settled law in Florida that a party moving for summary judgment must show the absence of any genuine issue of material fact.
And that's where the standard makes a difference. In reading from our Supreme Court, it will no longer be plausible to maintain the existence of any competent evidence creating an issue of fact, however credible or incredible. And isn't that a big difference from what we had before?
No, respectfully, Your Honor, it is not. In Blue, it was a question of interpretation of the painter's agreement. Here we
No,
can.
I'm talking about the standard itself.
The
I mean-
standard, but again, the Blue Court did not look to, in terms of the standard itself, the standard under Rule 1.510 is largely the same in terms of pointing to a genuine issue of material fact. We argued this case under the new standard, and we can point to significantly probative evidence in the depositions and the agreement that reflect this right of control, which was the same legal standard that the Blue Court used. It was the question under the jury instructions and Nasworth also. So here, Mr. Hernandez was performing work not to his own standards, but he was hired to paint according to Premier Fine Homes standards. And the Gradia Court, again, follows Blue as to the legal standard, also interprets the agreement in that case, along with other evidence, to find that there is a genuine issue of disputed fact.
How long had Mr. Hernandez been working with Premier?
I'm sorry, Your Honor?
How long had Mr. Hernandez been working with Premier?
It's a little unclear from his deposition. He wasn't sure if it was 2015 or 2016 or 2017, but at least since 2017, because we have invoices from the paint vendor that he was required to use that were addressed to both his company and Premier Fine Homes. And so we know from at least 2017, so he had worked for them at least 2 years before this agreement was ever entered into, and he continues to work for them today, and he's earned hundreds of thousands of dollars in 2021 alone, working 51 or 52 weeks a year for that company. I'm almost out of time, so
Yes, you're
thank you.
well into your rebuttal time. However, in view of the questions, we'll extend your rebuttal time by 3 minutes, and we will also extend counsel for the appellee's time
Thank
by
you.
an additional 3 minutes.
Thank you.
Counsel. You may approach, counsel.
Thank you. Good morning, Your Honors. I'm Danny Manassa, along with Juliet Diaz. We represent the appellee in this case, Premier Homes. The trial court got it right because the material relevant facts are not in dispute. Here, the court has told us in Gradia we start with a review of the relevant agreement. And here, the subcontractor agreement, it's a few pages long, and it's very simple. It creates an independent contractor relationship. Of great import, nowhere in that agreement does it reference the word paint. Nowhere does it say painter, painting. No reference to the word policy, procedures, regulations, hours, staffing. It is a simple agreement that sets forth a simple relationship. And that's critical because this court in Blue, in Gradia, and Operations Management, summary judgment was found to be inappropriate, and the court said because the agreement itself created a question of fact. Here, by no stretch can this 2 to 3 page agreement be deemed to create a question of fact. And I think Gradia, and it is under the new standard, but what's really important about that case, this court said the 4 corners of the agreement created an internal question of fact, because in that case, the hospital had an emergency room department, they outsourced the work, and they wanted those doctors to be deemed independent contractors, and they called them independent contractors. But then this court said, but wait a minute, your agreement calls them independent contractors, but then it dictates everything. Who do you hire? How do you hire? How much do you pay them? Level of staffing, level of pay. And so this court found that those inconsistent provisions created a question of fact. Now, to answer your question—
On the other hand, counsel for the appellant relies on our opinion in Del Pilar in support of their argument. Can you distinguish the facts of Del Pilar from the facts of this case?
Yes, Your Honor. Just like in Gradia, that dealt with the DHL driver. So the driver was giving a very detailed list of policies and procedures about how to do his job. And the court in great detail went on to state that the driver was told how to sort mail, how to prioritize mail, how to deliver mail, what type of uniform to wear, what does your vehicle look like. Every aspect of the gentleman's life was dictated by the agreement. And in fact, this court said that no detail was left undictated by the agreement. And here, there is no control there is no control over Mr. Hernandez created by the agreement.
Well, a few questions. I could say, let's first start with, what about the appellant points out the right to unilaterally terminate the contract for Premier. Why isn't that a factor of control here?
That's an interesting issue. If we look at the agreement, there is no reference to termination. The word terminate is not used. And it's not a term agreement. This is an independent contractor agreement that sets up the relationship. There's no reference to pricing. There's no reference to how the gentleman's to be paid or what he's supposed to do.
Okay, so let's go to another argument made by the appellant. It's the priority of painting the houses, where to go, what time, which house.
My client is a general contractor, and this gentleman, Mr. Hernandez, was paid by house. So each house is an independent oral contract, if you will. And certainly the general contractor has the right to say, do 111 Elm Street first, do 112 second. And what's critical about that, priority of houses has nothing to do with method of painting. If we look at the jury instructions where it defines an independent contractor, the standard jury instructions 401.14, it says independent contractor is a person engaged by another to perform a specific work, here painting, according to his own methods.
Sure, and so that's another question. The appellant makes much that Premier told Hernandez to use PPG paints and specified the color.
And I think here it's a misapprehension of final product control over methodology control. Because we do not shirk from the fact that we're the general contractor and we control the final product. We have to, because we have a statutory duty to make sure the home is built to code. We have a statutory duty to make sure the home is safe. We have a common law ability to make sure the home isn't built negligently. We have the ability to control the final product, but
And maybe
not-
the homeowners may have something to say about that. Do homeowners have any involvement in paint color selection, at least with regard to Premier paint?
In my family, one homeowner definitely does, probably not me, but yes, for sure, homeowners pick colors, they pick texture, but that's not methodology. Methodology is about how you go about doing your work. Here, there's nothing about primer, drying times, levels of coats. It's all about finished product. And I really think
Were
that's
there,
the,
were there any directions as to how to paint the trim on the various houses by Premier?
there was deposition testimony that my client had the ability to do that. And what's interesting, when counsel read the deposition transcript, she said something very telling. He said, I could do that, but I could charge more. I would be charged more, meaning that would be what's called in the construction industry a change order. If my client starts getting involved in methodology, sure, they're the general contractor. General contractors can dictate that would be a deviation from their agreement, there would be a change order.
There was evidence that Premier taught Hernandez how to paint soffit and fascia, but was that requested by Hernandez, and does that make a difference?
I do not think it makes a difference. There's no authority for the position that training somebody renders them something other than an independent contractor. Giving somebody the expertise to do their job doesn't take away the person's expertise. And I think we have to look at many other factors that we're talking about the construction industry. Here, there's no dispute. He hired his own staff. He paid his own staff. He used his own equipment. And he was paid per house. All of these factors are really, really critical in the construction industry of somebody being an employee versus an independent
Well,
contractor.
another factor that the appellant points to is that Premier dictated the price without any competitive bidding for the painter. What about that?
I do not believe that's a recognized factor of any kind. How much he is paid, as a matter of fact, the appellant talks a lot about how much the gentleman was paid, which under the restatement shows that this is a specialized profession. You know, Cantor, the Supreme Court case, dealt with a grocery bagger, and under the restatement found that perhaps that was not a specialized profession. Well, here, since Mr. Hernandez was paid a lot of money, it follows that it was a specialized profession, because you wouldn't pay somebody a lot of money for something anybody can do, which is an opposite of a grocery bagger, which typically you can hire somebody to do with very little training.
What about, Mr. Hernandez? He named his company Premier Waterproofing and Painting. Isn't that him, evidence of him holding himself out, some affiliation with Premier Construction? What should we make of that?
I think the use of the word premier is immaterial. I think back in the days when we had yellow pages, if you looked up premier, there would be 5 pages of the word premier. And here, there's no claim of a parent agency or a parent authority, so I do not believe it's germane to today's questions.
Was there any evidence in the record that Mr. Hernandez worked for other general contractors other than Premier?
Yes, Your Honor. As a matter of fact, the record shows it's undisputed that he did work for other developers, he did work for other home builders, and he did custom work for homeowners, which again is a critical factor of an independent contractor. Unlike the gentleman who delivered for DHL, who is required to use a uniform, drive a car with logos, here Mr. Hernandez did not have a uniform affiliated with my client, did not drive a vehicle with my client's logo, and in fact, made his living painting for other developers and contractors. So I think it's a very on-point question.
Well, I'd like to ask a couple of questions about the restatements. I mean, the best I can tell, the Florida Supreme Court hasn't cited the restatement of agency since 2003. And I'll read from Kansas versus Nebraska and Justice Scalia's statement, which is, over time, the restatement's authors have abandoned the mission of describing the law and have chosen instead to set forth their aspirations for what the law ought to be. Why should Florida courts continue to give credence and authority to the restatements at all?
Your Honor, I need to be very candid. I've been doing my research, looking to see how the record evidence complied with the restatement. But here, as a practitioner, I think anytime you have guidelines, if they're accurate, it's helpful. But I do believe that sometimes the restatement can be a little bit rigid and not applicable to every profession. So it would seem that if they were guidelines, the court has the ability to make them malleable to the situation at hand, I still think they're very helpful. And you didn't ask, but I still think if we look at the restatement, and I won't bore you with going through the restatement, we briefed it, but I believe each and every element dictates affirmation of the summary judgment here. And lastly, Your Honors, I just want to point out, I think, where is the gulf between the appellants and the appellees? In here, I think it's a misapprehension of control over the product versus control over the methods. And those are two different kettles of fish. My client clearly controlled the final work product. We do not shy away from that fact. But there's no record evidence that my client controlled the method of how the work was to be done. And I know I have more time, but I believe we've thoroughly briefed this. Did the court have any other questions they'd like me to address?
Thank you, counsel.
Okay. Well, I would close by saying we believe the record supports the trial court's decision, and we ask that you affirm it, and thank you for your time this morning.
And thank you, counsel.
May it please the court, the restatement factors are not rigidly applied in the case law here. It is not as if courts have looked to and done a weighing analysis as in, 4 factors apply here and 6 apply in the other, and therefore we must reverse and find a disputed issue of material fact. They do look to the totality of the circumstances, to all the conduct of the parties, and where there is evidence that belies the labeling of the independent contractor relationship, whether in other terms of the agreement or the conduct of the parties, that is enough to look to all those circumstances. Defendant represents that the bulk of Mr. Hernandez's work was working on behalf of other contractors and private individuals. When you look at and compare the only other 2 home builders that he could remember were Tallahassee Homes and Mike's Quality Construction, and he earned $30,000 or $40,000 from each of them in 2021. Here, he made $875,000 plus from Premier Pine Homes in 1 year alone, and he worked for them almost every week of the year, if not every week of the year. He was paid every Friday. The checks were payable to Mr. Hernandez and his Premier Waterproofing and Painting. Here, the facts show also that you mentioned, Judge Rowe, that this warranty work or these repairs were typically when a homeowner might be in contact with the individual. But here, there's evidence that Mr. Hernandez was asked to do that work by Mr. Jasvini, and that on occasion he did that work for free. On occasion, he did do warranty and repair work, and Premier Fine Homes agreed to provide his tools and materials for that. And so again, that goes to show more in the nature of an employment relationship or an agency relationship, where he is expected to do and will do whatever it is that he's asked to do without a competitive bid process. I would also refer this court to pages 734 and 735 of our summary judgment response in the record. And there it details just exactly how Mr. Jasvini gave instructions to this painter about what to do in the house. You directed him about what items to do, and he responds he's going to make the homeowner happy. And you actually tell him how to do the paintwork. Darker cut around the outlets, right? You were telling this painter how you wanted the paintwork done, yes, and what you wanted the outcome to look like. So it's not simply a matter of specifying the product to be used. It is that he, Mr. Jasmini, actually instructed Mr. Hernandez on how to paint and what to do, and admitted that he had the right to not only tell him where to go, but to control his performance. And for all these reasons, we would ask this court to reverse. There are genuine disputes of material fact. Thank you.
And thank you, counsel, for your respectful oral arguments this morning. This concludes our oral argument for this morning. We are adjourned.
All rise.